Commonwealth versus Joe.
Thank you.
Thanks, so.
Good morning, Ms. Pietzes. As I understand, Mr. Doe is submitting and will not be arguing. Is that correct, Ms. Mellon?
And so I've been informed by the clerk's office. Good morning. May it please the Court. Judith Ellen Petrus on behalf of the Commonwealth. The Northwestern District Attorney had filed a motion to quash a subpoena seeking production of 2 videotapes of SANE interviews that had been conducted in her office, which did not result in criminal prosecution. The parties seeking the videotapes were the 2 minor plaintiffs who had been the subjects of the interviews and their parents in a lawsuit that they had instituted against 4 different entities deemed to be responsible for their supervision of their elementary school. Where they
What is the role of the government in claiming the rights of these targets?
Well, the difficulty is that the targets were never given a voice. They didn't, to the best of our knowledge, they may not be aware of this civil litigation. Their privacy interests are known to us because we have the videotapes, we're aware of what the videotapes include. But these minors have not been given an opportunity to assert any privilege or to request that their identity be not disclosed so as to protect them from the ridicule that the minor plaintiffs recognized because they filed a motion to amend the caption in their original pleadings, citing to the ridicule and humiliation.
Shouldn't we take it as almost a given that in other discovery already, the identity of the alleged perpetrators has been revealed to the school defendant? Would have to be. If the theory is you did not supervise the children well enough, they want to know, well, what children are you talking about? Doesn't the school already knows who these alleged perpetrators are? I mean, you brief talks about privacy interests, but it seems the identity issue is long past. The minor plaintiffs know who these people are. The school knows who these people are and what the allegations are. I don't quite see why that aspect of the SANE interviews adds anything in terms of invasion of the alleged perpetrator's privacy.
Presumably, the litigants within this particular case now know at least a general identity of the students as they were described as being older students who were at the same elementary school, because the duty of the school and the school administrators to supervise and protect the students doesn't flow from the actual identity of the students. It's more their classification as being students within the school.
Is it even conceivable that the counsel defending the school has failed to ask the plaintiffs in discovery who are the alleged perpetrators?
Well, the counsel defending the school has had the suit dismissed against them. The only party remaining,
the town,
yes, is the town of Roe. We're not a party in that, and while I would agree with Your Honor's skepticism that that has not yet occurred, I can't say with any certainty that it has. But the difficulty for the district attorney's office, and certainly for all district attorney's offices, is that this is not an infrequent request that is made for access to some part of our files, whether in a case that has gone through to criminal prosecution or for an investigation that concluded without giving rise to any criminal charges.
Could you address subsection F, which I mean the privacy? There are ways and ways to deal with privacy, but it seems to me that, you know, whether these would prejudice the possibility of effective law enforcement goes to the point that you're making now, which is that these requests come in on a fairly routine basis.
They do come in on a routine basis, and part of that whole investigative procedure is the underlying principle of encouraging people to come forward to report that they have been victimized by crimes, to come forward to indicate what they've observed as witnesses of crime without any concern that at some point that's going to be made public. This Court certainly addressed it in the John Doe grand jury.
But these are the people who themselves made the statements, and they're saying we want them and we might want to use them in our civil litigation. It's not a question of some third party forcing the disclosure of a statement that some other witness made. These are the same people saying, we want our statements for our trial.
But there's no way that those statements are admissible in their trial.
But how will this
They
interfere?
may indeed be.
Yeah.
It depends. You don't know. They may be useful for a whole variety of purposes.
Prior recollection recorded? I mean, there's any number of
Or
ways. that they-
Impeachment?
Impeachment. Or the defense is that the tale that these children are now telling on the stand has been, much rehearsed and refined through years of consultation with therapists and lawyers, and they want to say, no, here's what they said close in time before they'd talked to any lawyers or any therapists or anybody that might have influenced. It could come up in a whole variety of ways, it seems to me. And all they're saying is we want to have it so that if we need it, we have it. And the trial judge will decide how it gets used or
Used
not
at trial.
used.
Right. But I would say the substance of what they've said is available and may already have been made available through depositions, both of the minor
that's
children
not the same
and
thing.
the forensic interviewer.
But you keep saying that this will deter future investigations and deter people from coming forward, but these are the people who came forward and who made the statements. So how will releasing these records in this specific instance, or a rule that's narrowly crafted to cover the people who made the statements themselves wanting to see them, how will that deter future victims from coming forward?
Because in a future instance, it may not be the complainants who are making the
can be
request, but
dealt with.
rather
That's
the
a
other
different
party.
thing, but that's not this case.
But-
So I'd like to know, you keep saying in your brief, and you keep saying now this is going to harm us in future investigations, but I'd like to know how this, when you consider this factual situation, that it's the people themselves who made the statements who want to see them.
The general reluctance within society for people who have been victims of sexual assault to come forward generally, and assuming that these are lay people for the most part, are not going to appreciate the fine distinction that at some point it was the actual complainant who requested release of the materials. They're just going
How
to
are
be
they going to
aware that
even-
it's going to come out.
How are they going to even know about it?
Well, assuming that there is ever a trial in this particular claim with the one remaining defendant, that will presumably get press coverage because of the fact that it's school officials who are being accused of neglecting to provide for the safety of youngsters within the elementary school. And that people will be allowed to discover that materials that had been provided with some degree of confidence to the district attorney's office now had become available for use in a civil litigation.
But if that rule, if we adopted that line of reasoning, it would mean that this stuff could never be turned over, no matter what. The exemption would be absolute.
Which is really what this court had already said in Attorney General v. Tufts, and just noted that there hadn't been any subsequent case decision that had overruled that holding that the confidence level is absolute, that people need to be able to come forward to the district attorney's office and law enforcement secure in the knowledge that the information won't be released. But then it was the public records law.
But the
that came in
information
that
that people give you is released every day. I mean, when you take statements from witnesses, eventually you have to turn them over to the defendant under certain circumstances. I mean, that happens all the time.
Right, but
So how is this so different?
within the range of the criminal proceeding, there would be a number of protections. Had these minors been formally charged with a crime, they would have some protections built into their privacy.
You're shifting the question. You've been talking about not deterring victims from coming forward. So now you can't shift and talk in the same discussion about the defendants or the suspects. Your concern is that you can't prosecute, you'll be harmed in future investigations because victims won't come forward. So let's stick to victims.
And in this instance, because of the victims coming forward, it's difficult to deal with in a vacuum just because of the nature of the sane interviews and the proceedings that we have as to how victims are.
This stuff gets turned over all the time, and the layperson out there against whom a crime is committed 5 years from now isn't going to think, oh, it was turned over during discovery in a criminal case, or it was turned over under an order to discover in a civil case. I mean, be realistic.
Well, but within the criminal case, then it's against the accused. Here, the accused isn't really a party to this particular civil litigation.
Well, but I mean, it strikes me that's why we ask judges to look very carefully at the circumstances, and the judge did here. I assume he heard all these arguments and concluded in the circumstances of this case the material could be properly released under the various statutes, protecting privacy and protecting investigative files. So why shouldn't we respect that judgment? Seems to me it was pretty carefully done. I mean, I understand your concern about we don't want, our files shouldn't be open for whoever wants to get a piece of them in connection with some unrelated proceeding without some fairly careful sort of inspection of what's going on here and whether that would harm law enforcement or would harm, inappropriately disclose matters covered by the privacy statute. But it seems to me the judge has sort of gone through that analysis here, and why shouldn't we respect that?
The judge in his decision really focuses on the privacy of the minor complainants and goes on to say that as to any other minors who may be included or discussed within the videotape, that they didn't merit protection. And it appears as though he really overlooked the fact that there were a number of other minors who are discussed within the videotapes, and he paid no attention.
Well, one of the problems, as I understand it, is the assistant district attorney hadn't viewed the tape. Is that correct? Before she argued this motion?
It does appear that way, Your Honor.
So, I mean, if the district attorney had come in and said, look, these are statements made by these plaintiffs now want to get their statements, but we can't turn them over unless we can redact at the plaintiff's expense this videotape so that every time they mention a word, I mean, if there was some privacy interest, the judge said, well, does this even mention by name who the perpetrators are? Answer, I don't know. I mean, it's hard for the Commonwealth to now say, well, what the judge should have done is to take into account the privacy interests of the alleged perpetrators. I mean, the Commonwealth's point is not a frivolous point here, but the Commonwealth wasn't giving the judge any assistance or saying what we can do is give a written transcript of the videotape prepared at the plaintiff's expense. I'm not putting the Commonwealth to any expense, and then redacting the names, if that's the issue. It does seem to me, Ms. Pearce, that you're struggling uphill where that's the very people who came forward, and the Commonwealth is saying it's the victim's privacy interests.
And I understand that, Your Honor. I think the concern of the Northwestern District Attorney is that to have a defined guideline as to when individuals who have been complainants come forward and request materials, what, if anything, are they to be provided for their subsequent use in civil litigation or whatever their request may be.
I mean, I can certainly imagine a circumstance where the victims have identified, 6 people by name, and it turns out that 5 of them weren't even in the school on the particular day, and that there's a very real interest that their names not become public, and that the Commonwealth could move. And I think, again, I at least understand why the Commonwealth may have standing to do that, because you don't want to put the burden on, completely innocent people to come in and protect their rights. But that wasn't done here. We can provide guidance for that, but that wasn't done here. Here, because the Commonwealth understandably coming and saying, these are our records, nobody gets to see them. It seems to me what the Commonwealth was essentially saying in that case.
The transcript is somewhat garbled, and I was not present for the argument in this, so it's unclear to me exactly what was put forth. Certainly a straight read of some of it indicates that couldn't possibly, certain words could not have been said in a particular order because it's nonsensical. But I have had the opportunity to view the videotapes, and I do know that individuals were named, and that redaction would be very, very difficult because this is in flow of conversation of 2 young boys relating events. But I recognize that was not presented to the judge below.
Let me put it this way. The one piece of the judge's order with which I did have some concern goes to this. He concludes that the extent the videotape refers to any other minor as witness or accused does not invade their privacy interests as the accused, let's say, of any individual named in the interviews already named to plaintiffs, well, that doesn't make it public, and is likely to be the subject to public disclosure in the trial of this action. Well, it wouldn't be likely to be the subject if, in fact, there's no evidence to suggest that that particular accused was at school that day or had anything to do with this and so on and so forth. That's the piece of it that did trouble me. There is a lurking privacy interest here for third parties who are not seeking their own. I just don't know, however, what the factual basis in this case is.
Perhaps the resolution in this matter then would be a remand back to the Superior Court for further hearing on the matter, perhaps an in-camera review of the videotape so that the judge is fully apprised of exactly what the situation is and perhaps better able to understand the privacy interests of other minors.
I realize your time is up, but do we
advances.
have any indication in this case at this point that the minor plaintiffs are now making different accusations involving different people than the ones they identified in the original sane interviews? Or in other words, do you have any indication that there's any discrepancy between the version that they're now putting forward in their civil case and the version that they gave in their sane interviews?
Certainly within the face of their complaint, they are alleging a far longer period of time and many more occurrences of...
In terms of the identities of the perpetrators,
Well,
they haven't expanded or shrunk, I mean...
It's unclear because in their complaint, they only talk about it being 3 older boys. They don't... So it's very unclear to us because we're not party to any of the discovery that's gone on.
In the videotape, they named 2 or 3 alleged perpetrators.
Actually, they appear to allege, one appears to allege 4 perpetrators.
Okay.
And the other one would allege 3.
By name?
Yes.
So there's at least a 4th who is dropped out.
Well, who perhaps may only be viewed as a witness. It's unknown to the district attorney's office what information has been provided by the plaintiffs to counsel, so that what we're viewing is one aspect of it which may not be known to counsel.
I understand that the judge was quite dismissive of the Commonwealth's claim, but is there any basis for us to take into consideration any Corey implications here?
My understanding of the Corey statute is that there'd have to be a criminal proceeding, and as there never was, I don't believe that there is an implication of the Corey statute here.
Thank you, Ms. Pietras.
Thank you.